Good afternoon. Today I will be interviewing Mr. Frieder Roessler, the Executive Director of the Advisory Center on WTO Law, and Mr. Ricardo Meléndez-Ortiz, the Chief Executive of the International Center for Trade and Sustainable Development. The Program on Dispute Settlement and Legal Aspects of International Trade at the International Center for Trade and Sustainable Development has recently launched a book published by Cambridge University Press entitled Dispute Settlement at the WTO, The Developing Country Experience. It is co-edited by Mr. Gregory Schaffer and Mr. Ricardo Meléndez-Ortiz. It is a bottom-up assessment which deals with the experience of developing countries in WTO dispute settlement. It consists of 9 case studies from various continents that look specifically at what these countries have done in order to meet the challenges that the WTO dispute settlement poses on them. Mr. Roessler, could you give me, from your own experience, maybe a little insight? Are there any other reasons why it would be important for developing countries to further increase legal capacity and to strengthen their internal domestic legal capacity beyond dispute settlement?
Mm-hmm. Legal capacity is, of course, very important for developing countries to develop so as to assert their rights in dispute settlement procedures and to defend their interests also as respondents in those procedures. But legal capacity is also required for many other purposes. One purpose is to be able to participate effectively in the WTO's decision-making and negotiation process. In order to be able to understand negotiating proposals, you need to have a minimum of knowledge on WTO law. In order to be able to know what a waiver proposal, for instance, really implies for your country, you need to make a legal analysis. Therefore, for that purpose too, it is extremely important to have dispute knowledge in WTO law.
And what would you say are the main challenges for developing countries to build this very much needed legal capacity?
Yeah, I think there are 2 challenges. One lies within and the other one lies without. The developing countries must be internally organized to make effective use of their WTO membership generally. And then the external element is perhaps to obtain assistance when legal issue arises. But let me emphasize this again, and this has been also an emphasis of the authors of this book. There is also necessary an institutional capacity. It's not only necessary to have a personal capacity. The persons that are trained in WTO law must also be able to operate within their countries in an institutional framework in which they can make effective use of their knowledge for the benefit of the country. And that, I believe, is one of the main challenges that the smaller developing countries are facing, and challenges which they can perhaps resolve by examining the experience of the larger developing countries that have already adapted internally to these new requirements.
You're just mentioning the larger economies. I think we've seen some very positive lessons over the last decades, especially within developing countries. If we look at the current numbers, for instance, we see that 7 out of the 11 most frequent complainants at the WTO are indeed developing countries. This includes mainly larger developing countries, if you can say it that way, including Brazil, Mexico, India, Argentina, Thailand, for instance. But would you two say that there are any valuable lessons we can draw from that? Maybe Mr. Meléndez-Ortiz.
Well, each country has a very different experience with dispute settlement, as they have a very different experience and relationship with the WTO system. In the cases that you mentioned, perhaps it's good to focus on those that have had a systematic approach to developing capacity and participation in dispute settlement, the WTO. There are others that have successfully use the system. And there's always the possibility of buying, if you like, your litigation capacity and your preparation in a case. But that doesn't substitute for a systematic institutional, again, preparedness, which I think is what Frieder was referring to before. And among those countries that you have mentioned, the case of Brazil, which is detailed analytically in the book, is a very interesting one. So you have a country that for years has been building capacity within the ministry that is responsible for international trade negotiations. It has been building a network of support and contacts with the private sector and other stakeholders interested in WTO negotiations. It has a systematic dialogue with those in the private sector that use the system, such that when a case comes up, then again, all the infrastructure is ready there to support the participation of Brazil in the case. It also includes a number of elements that are very interesting for others to take into account and perhaps follow. WTO law now is taught at a number of faculties of law and universities dealing with public policy and international relations in Brazil. So there is already sort of a court of lawyers and specialists within the legal system in Brazil, not necessarily in public office and not necessarily in the institutions that deal with the WTO, that is ready to contribute, again, in the case of an episode where they may need to go to dispute settlement.
You just mentioned the example of Brazil. I think the book outlines another 8 examples of how countries have gone along in establishing legal capacity, and they differ immensely from each country to each country. Mr. Roessler, would you say that there is something general we can take from the lessons? Can we apply them to all countries in the same way? Or how do we have to go along with applying these lessons for the future?
Well, the way a country organizes itself internally to make effective use of its membership in the WTO, that will necessarily vary enormously from one country to the other. What I observe is that there are really now 2 groups of developing countries involved in the dispute settlement procedures. There is the group of very heavy users, including China, Brazil, Chile, Mexico. And then there's a group of developing countries that is involved in the dispute settlement procedures only very occasionally, perhaps 2 times since the inception of the WTO, 3 times, 10 times, but not as often as these very, very heavy users. Now the heavy users, they have gained experience. They don't need external assistance any longer, and they have therefore also not asked to become members of the advisory center of WTO on WTO law. Our members are all the infrequent users of the dispute settlement system. If you use the system only once a decade or twice a decade, you do not develop the capacity necessary to become, to use these procedures very, very effectively. You have to turn to external assistance.
And if I may add this as some sort of afterthought, how about those countries that focus primarily either on regional trade or trade, for instance, under preferential agreements? Can we still expect from these countries to build the same legal capacity in the same way? Is it going to pay off in that sense, or is a completely different approach needed for these group of countries in terms of support?
Yeah. I think you are asking a very valid question that is rarely discussed. There are countries for whom it would simply not be efficient to build legal capacity. It is better for them to turn to outside help on the few occasions in which that capacity is required. Think of a small Caribbean island country with a few 100,000 people as inhabitants. It will not pay off to have legal capacity. It is much better that they turn systematically for external help the moment a legal issue arises. And in respect of those countries, we are serving almost as the same function as an internal legal office. You know, larger countries all have legal offices to whom any officer in the government can turn to ask for legal advice on WTO matters. We provide that legal office to those small countries, and we don't consider it necessarily to be a primary objective to build capacity in these countries.
Mr. Meléndez-Ortiz, the book assesses, amongst very, very many other issues in the 9 case studies that are presented in the different chapters, it assesses in depth the role of the private sector and private actors that are active in countries in general that work on trade issues. And one of the recommendations or conclusions from the book is that the private sector plays a very critical role through the whole extended process of dispute settlement, starting with trade barrier identification and ending with the actual implementation. Would you agree on this assessment of the role of the private sector, and how do you see sort of the support of the role of the private sector to be pushed forward? Do we need to ensure a certain balance or certain restrictions also on this role?
Well, I think that the book takes from what Professor Schaffer calls and has published on public-private partnerships in dispute resolution. Which basically it's a recognition of a reality in trade and trade policy, being that trade policy has to be made and has to be implemented and practiced very much in consultation, if not sometimes association, obviously, with your productive sectors, as exporting sectors, but also other stakeholders that are usually non-state actors. How much should the private sector intervene and participate with the government in a dispute case? I don't think that there's one formula that you can use to decide, and it's really a case-by-case question.
I believe that the involvement of the private sector is in the disputes before the WTO is usually absolutely essential. The private sector has the information, the initiative, and you cannot really conduct an effective dispute settlement process in many instances without the support and the information provided by the private sector. Having said this, I would like to emphasize that the interests of the private sector in a WTO dispute settlement procedure and the interests of the country as a whole are not necessarily identical. The private sector might make arguments, present arguments that the country as a whole would probably not wish to have accepted by the panel, because maybe the arguments, if accepted, mean that the country itself is violating the WTO. Or the economic interests of the sector might be completely different. The private sector might be interested in some kind of self-restraint arrangement, whereas the country as a whole might wish to promote its exports to the maximum, to promote employment. Therefore, there is a difference very often between the private sector's interests and those of the country as a whole, and therefore the control over the dispute settlement proceedings cannot and should not be given over to the private sector completely.